Hello, everyone. This is Tom Fox. I'm the Compliance Evangelist. Welcome to episode 35 of This Week in FCPA for the week ending January 13th, 2017, the Friday the 13th edition. In this episode, I'm joined as always by Mr. Translations, Jay Rosen. Jay and I discuss the guilty pleas by two individuals, Mr. Hernandez and Beech, for bribing PDVSA, or the Venezuelan National Oil Company officials. We discuss the VW guilty plea and its emission testing scandal and the individuals who were charged in that scandal. We talk about Oliver Schmidt, the VW executive arrested in the United States earlier this week. We discuss the Zimmer Bio-Met FCPA enforcement action follow-up. We talk about the Mondelez FCPA enforcement action. We discuss a Supreme Court case which takes a look at whether the profit disgorgements are subject to a 5-year statute of limitations, which apply to forfeitures, or appropriately a remedy under injunctions. We give our predictions on the NFL weekend division games. The episode comes in at a little over 35 minutes. This is Tom Fox. I'd like to thank you very much for listening to This Week in FCPA. Hello, everyone. This is Tom Fox, the Compliance Evangelist. I'm joined by my good friend and colleague, Mr. Translations, Jay Rosen, for This Week in FCPA, the weekend of January 13th, appropriately named the Friday the 13th edition. Jay, it's 82 today, and it never rains in southern Texas, so welcome.
It is a nippy 60 here in Southern California, and it's been raining here for the last week and a half. We're loving it. The only person who isn't loving it is Latka the Wonder Dog, who has been having to stay inside the house instead of going out on his long walks.
Well, Jay, we've had quite an interesting, significant, and busy week in the FCPA for the second week of January. No real blockbuster cases as we saw in December. Nevertheless, I thought some important cases that enforcement actions and related information that we should talk about this week. Of course, we have the divisional round of the playoffs this weekend, so we'll need to pontificate on that. And last week we had some subliminal messages about them Cowboys, and this is the week where all that sublimination comes to fore, hopefully.
Well, I'm looking forward to a week of competitive games, unlike last weekend. So hopefully we get our wish, and we still continue on that collision course for Cowboys and Patriots.
So, Jay, we had a FCPA enforcement action against a company called Mondelez. Mondelez is a successor to the Kraft Foods Company, or formerly known as, and in 2015, they acquired Cadbury, a UK-based confectionery and snack beverage company, although I know them as the chocolate guys from the UK. And in that acquisition, they picked up a Indian subsidiary, appropriately named Cadbury India, who it turned out may have paid some bribes through an agent for permits in India. And although the fine was relatively low, at least in FCPA standards of $13 million, I thought it was quite interesting because there was no evidence that a fine was paid in this case. A bribe was paid in this case. And what the SEC, this was not a criminal enforcement action brought by the Department of Justice, but what the SEC found was that, number one, the books and records did not accurately reflect the nature of the services rendered by the agent, without specifically saying that the agent paid bribes. And then there was a second component under internal controls, which found that the agent could have used the payments made to it for the purposes of bribes, and there weren't sufficient internal controls to prevent that. Once again, the significance or really interesting thing is that there's no evidence of bribes being paid laid out in the SEC complaint. So I thought that we rarely have these types of cases and where there's no evidence or even indicia of a bribe being paid. And so there's really only one other case that I could think of that was similar to this one, and that was back in 2012, I think. Oracle was sanctioned by the Securities and Exchange Commission for having a subsidiary which parked a portion of its proceeds from certain sales to the Indian government, and the money could have been used for unauthorized purposes. So basically, we have a situation where an agent, it was clear the agent did not go through appropriate due diligence. There's no exception granted, which would allow the agent to go through and become a distributor an agent without due diligence. Nevertheless, there's no real evidence that a bribe was paid, although there was, perhaps you could guess that. Nevertheless, that was not the allegation brought forward. For me, the significance of this case was that you actually have to do compliance. And if you have an agent or a distributor and they're paid money, you actually have to go audit and see how they're using the funds. The agent was paid, I think, a little over $100,000 over a period of 6 months. And the money was taken out in cash by the agent. And from that point, there was no audit trail as to what the money was used for. So I think it's a pretty important lesson for companies that they have to have audit rights. They have to actually exercise those audit rights. They have to monitor their third parties. And that India is a country which may bear some scrutiny if you have a business unit there or you operate through a third-party representative such as an agent or a distributor, so that you may need to take a look at that if you were a compliance officer with a company with such business operation.
And, I would also want to look at it from the other way, Tom, that quite often we talk about, doing compliance and doing the due diligence, but in this situation, it was under the context of an M&A transaction. So one of the things where I believe Mondelez was rewarded is once they began the integration of the companies, they started to find out that there was an issue in India. They investigated, they began to remediate, and they took care of it. So I think a lot of times, not only do you need to be responsible for those third party and agents, when you're running your company and if you have overseas operations and branches, but particularly even more so within an M&A context. And, I think there's maybe similarities here to like Alstom and General Electric. So if you're going to be doing an acquisition, and when you start doing your due diligence, at the same time, you should be really doing some ethics and compliance and FCPA due diligence. And what you might find out in those investigations is that this may be a company that you don't want to acquire, or I would guess in the in the case of GE and Alstom, they started to factor in some of the costs for remediation, and that allowed them to reprice the deal in a more favorable manner.
And you raise a great point, Jay, because I'd focused on the accounting provision violations of the FCPA, but you reminded everyone, myself included, in addition to our listeners, of the need to do pre-acquisition due diligence and then post-acquisition auditing of your compliance program. And unfortunately for Mondelez, the SEC complaint specifically noted that Mondelez engaged in an internal investigation around Agent 1, but post-acquisition due diligence did not identify the relationship between the agent in question, which was identified as agent number 1 in this SEC complaint, and Careberry India. So it looked like a whistleblower or other tip came into Mondelez, which allowed them to make this determination and lead to the agent's termination. But you've got to do a adequate job either in your pre-acquisition due diligence or hopefully in your pre-acquisition due diligence, but most certainly in your post-acquisition FCPA audit and integration. So lots of lessons from this case, even though, once again, we have to emphasize there was no evidence laid out in the SEC complaint that bribes had been paid. So we also had something that's rarely seen, Jay, this week. We had a two-time loser pop up. A company that was under a deferred prosecution agreement was found to have engaged in additional FCPA violations. It's a fairly long and complicated and tortured matter, but it's Zimmer Bio-Met Holdings. Bio-Met had sustained a FCPA charge back in March 2012 and paid $23 million to settle that enforcement action, had entered into a DPA and retained a compliance monitor for 3 years. And maybe you could pick it up from there.
So after they've, started to meet the levels of the DPA, something came up again with once the new two companies were merged, and they were not at that point living up to the terms of the DPA. So again, they started to run an internal investigation, started to take steps to remediate, but by falling out of the terms of the DPA, they need to enter into a whole new set of agreements. So I guess that gets you back to our initial statement about them being a two-time loser.
So Jay, actually I worked for a company that was found to have sustained additional FCPA violations while under a deferred prosecution agreement. And from that experience, I can tell you that the Department of Justice does not look favorably upon companies that engage in FCPA violations after having signed a DPA promising never to engage in FCPA violations. And I often reflect back to my views as a teenage boy and what I might want to tell my parents about what I was going to do when I went out at night. And it was generally along the lines of, I would not seek permission, but I would ask for forgiveness after the fact. As the father of a teenage daughter, now former teenage daughter, my views on that have evolved. And they have evolved to, I would prefer to be asked permission first rather than sought forgiveness after the fact. So that's similar to what the DOJ, I think, feels. And they certainly do not take kindly on this. Bio-Met had their original DPA extended. The monitor was not able to report that the company had successfully completed the terms of the DPA, and now they get a fine and penalty of really a little over twice what they originally paid. So a very expensive lesson. If your company is under a DPA, you have got to make sure you don't have additional FCPA violations. Now, but if I could maybe take a step back, if there were not new FCPA violations, but it was continuing conduct which should have been discovered in the original internal investigation, that's also an important lesson to be learned, that when you investigate your company, you need to uncover everything and you need to turn it over to the government at once. Because I suspect if had Bio-Met done that, then the fine and penalty would have been far less than the sum total of $30 million plus $13 million. But because they did not find out, or new conduct popped up, then we had this new and significant fine. Once again, though, Jay, we have M&A here where Zimmer bought Bio-Met, and Zimmer's on the hook for this. So even though they may try to pay it out of a Bio-Met business unit, it's all one company now. And to your earlier discussion about the importance of pre-acquisition due diligence, the importance of post-acquisition integration and FCPA audit, the Mondelez and Zimmer case really speak to that issue just this week.
So we now have some individuals who have gotten some guilty pleas and, have also been held accountable for actions. Should we take VW first, or do you want to do Hernandez and Beech?
Let me do Hernandez and Beech since we're on an FCPA rolling.
Okay.
So we have Two individuals plead guilty, one in Houston and one in Miami, around bribes paid by U.S. citizens to PDVSA, which is the Venezuelan national oil company. And it's really one of the most corrupt national oil companies around. I think even Petrobras would pale besides PDVSA. The joke was that it took a Rolex to get a meeting with a mid-level manager. So that, unfortunately, when that's the perceived to be the archetypal story, there's generally some truth behind it. But here we had two men paying money, wire transferring and paying cash in certain instances to Venezuelan officials, paid out of bank accounts into from the U.S. So we had with Mr. Hernandez relatively small amounts, $7,000, $9,000, one amount of $14,000, and then another of a little over $1,000. Mr. Beech paid a little bit more money, of $132,000 in one payment and $15,000 in another payment. They are allegedly cooperating with the United States government, so we'll have to see how that might shake out for their jail time at their sentencing. And the government press release noted ominously that its investigation of PDVSA is still ongoing. All of this means if you're a U.S. company and you have done business with PDVSA over the past 10 years, you need to make sure your house is in order. You need to do a very focused internal audit and investigation around all of your employees who dealt with PDVSA, any third parties you may have had, because one of the both Beech and Hernandez made bribe payments to get bills paid, outstanding invoices. And that's obviously very frustrating when you can't get your money out of a contractor or a country or a company. But if you've got to pay bribes to get bills paid, we've seen that conduct before with ADM in the Ukraine. So I would just urge you, if you've done business with PDVSA or indeed with the Venezuelan government over the past 10 years, you need to get ready for a country sweep now.
And which ones of our friends did you suggest that might want to, that should be called in these situations?
Matt Ellis at Miller and Chevalier.
Yes, who has a great book that's out too. And, he is a trilingual expert, so he's somebody who should be reached out to. In the other case that we're going to look at, it caused a little, a little bit of a blip within the compliance community because Oliver Schmidt, who was, an emissions compliance person at Volkswagen, working here in the U.S., but also going back and forth to Wolfsburg, was getting ready to take a vacation and was arrested in Miami International Airport. And, I guess the fear that was raised here is that a compliance executive was arrested and was, going to be tried. And I guess the one thing that we need to really be focused on is that term compliance does not mean that Mr. Schmidt was a chief compliance officer, but he was involved in the emissions compliance department. And his duties were supposed to make sure that Volkswagen's products conformed to the EPA standards. And instead, he was one of the individuals who were responsible for subverting those standards and for coming up with the defeat switch. And not only did he do this in the U.S., but he went back to the home office in Germany and informed them on the plan and perpetrated it even further. So I know Roy Snell quickly hopped on the internet and made a demarcation about the type of compliance executive that Mr. Schmidt was. But, I think this is all a good development, and it still furthers along the goals of what we're doing, whether it's from a FCPA or a fraud perspective, but to find the individuals who are involved. So this furthers on what's been happening for the last 18 to 24 months in our FCPA part of the world.
So let me just build on that, Jay, because Mike Volkov was very clear, really in another direction, which was, and of course, Mike's an ex-prosecutor, and he said it really doesn't matter what your title is. If you're a chief compliance officer and you engage in illegal conduct, you're going to be prosecuted, or at least you're subject to being prosecuted. So even if one accepts the title of compliance submissions officer, while Roy Snell's correct that it's not an anti-corruption compliance officer, if you engage in illegal conduct, simply that title of chief compliance officer is not going to protect you, and the Department of Justice is not going to target you for non-criminal conduct. The other thing is that of the individuals charged, they were generally involved with a cover-up. They were not part of the team that developed the defeat device. All of them, the couple of engineers involved, started after 2006 when it was initially installed. So this team was a part of the cover-up, and Schmidt's conduct was particularly egregious when you consider that in 2014, when he first found out about it, his question was, are we telling the truth? If we're not, we have to continue to lie. And then he took that message to VW management, who tacitly or expressly approved it. And then he dissembled when he met with the EPA and California Air Board in 2015. So he was directly involved in the cover-up at the corporate headquarters. He was directly involved in making misstatements to U.S. regulators, and all along the lines of the cover-up is much worse than the original crime. So we had active involvement by VW executives. From the criminal procedure perspective, it's just mind-boggling that Schmidt would travel to the United States when he was under investigation. He had counsel. He had met with the Department of Justice in London. Obviously, he had worked out some deal so that he would not be extradited from England. But here in the United States, he's subject to full U.S. Law enforcement jurisdiction. He has been arrested in Miami. He was transferred to Detroit. His bail was denied. He's looking at 167 years in jail. So I don't know who advised him to come here or what allowed him to think he would be safe in doing so. But I think that VW, as I wrote this week, Jay, VW executives may be vacationing at home this year because if you'll recall, we had a case with BizJet. The CEO was indicted, skipped out to Germany and decided to take a vacation and booked travel through Amsterdam. And at Schiphol Airport, he was arrested and extradited. So Germany does not extradite its citizens generally, but once you leave Germany, you may be subject to some pretty severe sanctions.
Maybe Mr. Schmidt had recently watched an episode of The Force Awakens, and as he was walking through the airport, he was sending out this subliminal message: this is not the FCPA cover-up artist that you're looking for.
Hopefully he was not saying go Cowboys when he was doing that.
I thought I'd get a kick drum or a snare on that one. So you want to quickly do the Supreme Court and the SEC, and then we'll do our playoff predictions?
How about some deep breaths from Darth Vader himself? So we had today, in fact, as the day we're recording, we had an announcement that the Supreme Court has agreed to determine whether the SEC is subject to time limitations when seeking ill-gotten gains in the form of profit disgorgement. And this is for you lawyers listening to this is just a great geek out in the weeds legal issue that basically turns on whether profit disgorgement is a remedy appropriate under the injunction prong that the SEC has available to it, or if it's under the forfeiture prong. If it's under the injunction prong, there's no statute of limitations on how far back the SEC can go for profit disgorgement. If it's, however, ruled to be a forfeiture, there is a 5-year statute of limitations. Mark Bong at Miller and Chevalier is really one of the leading commentators on profit disgorgement. I've talked to him about the underlying courts of appeals cases. I may have to get him back, but how it applies, Jay, in the FCPA world is the Department of Justice and SEC take the position that you have to give back all of your profits from the moment the corruption began. So if that's multiple years, or certainly before, and that can be 5 years, 10 years, anything in between. It could go back 20 years. So it can and really add up to a lot of money. And of course, the SEC charges interest upon that. It's not tax deductible. So it's a pretty significant question. We have a split in the circuits. The 11th Circuit has taken the position that profit disgorgement is a forfeiture and therefore subject to the 5-year statute of limitations. We've got the 10th Circuit, the D.C. Circuit, and one other one who have said that profit disgorgement on the First Circuit properly falls as a remedy under the injunction prong. So this could be pretty significant for FCPA enforcement, although the case that's going up is about a New Mexico investment advisors appeal, not an FCPA case. So very interesting, and hopefully I'm sure we'll have a decision sometime in 2017 on that, and may clarify a question, an open question, and one that's been split between the circuits. So I think we've got football this weekend.
Yeah, tell me about this 16-point spread. How did that happen?
Well, if anyone's listening to this, I rarely give out betting advice, but at 16 points, bet everything you got on the Patriots. I'm thinking of 21 to 25 point spreads probably more appropriate. Because while playing the Patriots' former third string quarterback, the Patriots lost 27-0 the first time. So
Texans.
I would say it's going to be a bloodbath, but I don't think Belichick will run the score up. Hopefully the Texans will show up, but they didn't show up the first time. They've never showed up in a playoff game, or at least under O'Brien, they haven't showed up in a playoff game. So who knows what they'll do. Unfortunately, I'm reminded of 1978 and 1979 Houston Oilers when they had the second best team in the AFC and went to Pittsburgh 2 years in a row for the AFC Championship. Unfortunately, the best team was Pittsburgh. The first year they went, they were absolutely destroyed by Pittsburgh, and Pittsburgh went on to win the Super Bowl. The second year, they were competitive and indeed probably lost by a blown call where Mike Renfro did not get credit for a touchdown in the end zone. But Houston professional football has long been known for being blown out in playoffs. As the Oilers have the record for losing the biggest comeback. I think 16 points is probably too low. So my money is on the Patriots this weekend.
So those teams in the 70s, was that the Snake Stabler or was that Dan Pastorini?
78 was Pastorini. 79 was Stabler.
Wow. See, I can occasionally make this mind come up with some good information, so I'm glad that came through. The other AFC game, I think it'll be close. I think it's about a 3-point spread. There's some statistic on how Andy, what's his last name? The case. Yeah, there's some stat that he's incredibly successful after a bye week, that he will just game plan the heck out of this. I think both quarterbacks are really talented. I think Smith gets a little bit of a bum rap as a game manager, but I look for that to be a highly entertaining game. And I think, it's tough to win at Arrowhead. So I think I would give the nod to KC.
So my only thoughts are there's a reason Mike Tomlin has been to 3 Super Bowls. There's a reason Ben Roethlisberger has been to 3 Super Bowls. Pittsburgh has one of the best organizations in the National Football League. Perhaps not as great as New England right now, but nonetheless very close. I'm as much as it pains me to say this, my money's on Pittsburgh in that game.
Okay. You want to do Big D now, or you want to go to the undercard Seattle?
I'll go to the undercard.
Okay. I somehow think that when Seattle gets into the playoffs, they're a team that can leverage their experience from having been there before. And although Matt Ryan is having a great year, I like the Seattle defense with the exception of one of the safeties that they're missing. But I think, again, that's a close game, but I see Seattle winning.
I'm going to join you on that one. Matty Ice may have ice in his veins, but the Falcons tend to be chokers. For those betting, the spread is 5 points, which I think is way too much. Obviously, Russell Wilson's not at his peak this year, and the safety you mentioned being out is University of Texas grad Earl Thomas, which definitely negatively impacts the Seattle secondary. Nevertheless, I'm going to go with your leaning. I think Seattle has more playoff experience. They certainly have more Super Bowl experience, and I think they're going to answer the bell in Atlanta.
All right, and what you've all been waiting for is Tom Fox's pick on the Dallas-Green Bay game. This has been a historic rivalry over the past 3 decades or so, so I think this could be a little bit of a changing of the guard here if Dak is able to take down the Packers.
Unfortunately, Jay, you're showing your legs of youth. It's 5 decades of rivalry. So the pontificators have surprised me that they are leaning on Green Bay and having, of course, the greatest quarterback on the planet right now, Aaron Rodgers, leading them with their playoff experience. But Jordy Nelson's hurt, and he's Rodgers' top receiver. I think Ezekiel Elliott will continue to control the line of scrimmage. And if it gets into a 38-35 shootout, I think Rodgers probably has the advantage. But if the Cowboys can control the ball 55 to 60% of the time, they'll have a more balanced offense, passing and running. And I think the Cowboys take it at home.
And just promise me, if it comes down to a field goal, that Romo will not be holding.
We can only hope.
All right, so that's our playoff picks. As Tom said at the beginning, we are just into the second week of January 2017. Lots happening in our FCPA ethics and compliance part of the world, and we will start to see changes next week when the President-elect Trump takes over. So it'll be a very interesting week next, and I look forward to joining you and discussing things next Friday.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to This Week in FCPA. If you've listened to this podcast on iTunes, I would greatly appreciate it if you would rate it, as it would help in our rankings. And if you have any questions you'd like Jay and I to explore, please shoot me an email with them, and we'll put them in a mailbag episode. My email is tfox@tfoxlaw.com. This is Tom Fox. Thank you again for listening to This Week in FCPA.